The Chandler court, first of all, was asked to but did not overrule Estes. But what it did clarify, as the court just indicated, is that if the defendant wants to prove up a federal fair trial violation, it's his burden to prove prejudice. And the Estes court outlines that that can be done through an evidentiary hearing at which the defense would have the burden of showing, again, the factors under the James case, nature and extent of publicity, how it prejudiced the defense, whether there are reasonable alternatives. That's going to be the very purpose of the hearing, to comply with Chandler's mandate that we have the burden to prove that prejudice. And so we're going to be taking on that burden, and we think well establishing that we're entitled to the relief that we seek, which is some restriction on the type of prejudicial information that is flowing not only from the electronic media, but that electronic media being amplified by the widespread use of social media, which we discuss at length in the motion. I'm not going to get into the merits of the motion itself, but to address the concern the court had about, well, really Estes is no longer good law. Estes is cited favorably in Chandler. It's cited favorably in Hollingsworth versus Perry, which is the Supreme Court's most recent discussion of cameras in the courtroom. And the court is correct that Chandler put a gloss on it, that we have to show there is no presumption of prejudice, but there is a presumption of prejudice in regard to certain types of prejudicial pretrial publicity. And the clearest holding to that in that regard is the Schilling case.